Okay. Thank you, and welcome to everybody for joining our Lunch and Learn webinar today on employment and the Americans with Disabilities Act. We can go to the next slide. I am Jan Garrett, Deputy Director of ADA Programs with the Center on Disability and Pacific ADA Center, and I will turn it over to my colleague to introduce herself.
And I am Pat Swarth. I'm the Lead Technical Assistant Specialist for the Pacific ADA Center.
Okay, next slide. And so the Center on Disability provides education, advocacy, and support to advance the full and equal participation of people with disabilities in all aspects of society. And that's basically what the ADA requires all of us to do. At the Center on Disability, we are disability led, and 75% of our staff has a disability. And then our newest program is Beyond Access Consulting, where we do customized training on disability related topics, and we provide facility accessibility assessments. Next slide. So we're going to start with an overview of the ADA. The ADA was signed into law by President George H.W. Bush on July 26, 1990. So we just passed the 34th anniversary of the ADA. This picture actually shows George H.W. Bush signing the ADA with advocates around him that helped to ensure that the ADA was passed. The ADA is a civil rights law. It is important to understand that, and that any violation of the ADA is a violation of the civil rights of anyone who is covered by the ADA. In general, the ADA protects people with disabilities from discrimination and provides an equal opportunity. And the overall goal is the full inclusion of people with disabilities in all aspects of American society. The ADA does have some specific requirements, some of which we will talk about today. Any entity that is covered by the ADA has to provide reasonable accommodations to applicants and employees with disabilities, and we will be focusing on employment in the webinar today. You also have to provide accessible locations for your programs and services, accessible websites, no matter what kind of entity you are, whether you are a state or local government or a private company or a private nonprofit. You need to provide communication aids and services for participants and customers with hearing, speech, and or vision disabilities. And you need to provide reasonable modifications to some policies and procedures. And the ADA does have 5 titles which kind of lay out all these requirements. We will be focusing on Title I today for employment, but Title II is state and local governments. Title III is public accommodations, which are private businesses and private nonprofits open to the public as well. And then there's also commercial facilities that are located in Title III. Title IV is telecommunications, which primarily deals with access for people who are deaf or hard of hearing and have speech disabilities or have speech disabilities. And then Title V is miscellaneous, and that includes the specific provision that says you cannot retaliate against someone for enforcing their rights under the ADA. Next slide. So why does disability matter? Why do we need to know about this? The chances are good that you know someone with a disability right now. It's also very likely that you will have a disability at some point in your life. I am somebody with a disability, and many of you out there may be as well, but you certainly know someone or will know someone at some point in their lives. And people with disabilities deserve an equal opportunity to participate in everything our society has to offer: government, business, recreation, employment, everything. Next slide. So, some statistics or disability by the numbers. According to the US Centers for Disease Control, or CDC, 27%, or 1 in 4 adults, have some type of disability. And among people with significant disabilities, the percentage of disabilities that are invisible, quote unquote, or not apparent, has been estimated as high as 96%. So those of you who have or know people with non-apparent disabilities, you are in good company in a way, because up to 96% of people with significant disabilities, their disabilities are not apparent to people. Next slide. So apparent disabilities can cause fear or pity among those of us who have them, with the general public. And we most commonly face barriers and accessibility barriers to buildings and programs. We also face a lot of assumptions based on our appearance of what we're able to do and not do. Um, for non-apparent disabilities, those are not invisible or hidden by those who experience them. People are not intending to hide them. They just may not be apparent to everyone. And so people with non-apparent disabilities most commonly face claims of faking their disability or exaggerating their disability because other people cannot see it. Next slide. So, what is a disability under the ADA? The ADA does have a specific definition that has 3 parts to it, or 3 sections. It's a physical or mental impairment that substantially limits one or more major life activities. And you can see a partial list of major life activities in the box on the right that includes walking, seeing, hearing, speaking, breathing, cognitive functioning, concentrating, normal cell growth, and there are many, many more possible major life activities. So the first part, a physical or mental impairment that substantially limits one or more major life activities. You can also have a record or a history of having that physical or mental impairment, or you can be regarded as or assumed to have that physical or mental impairment. Any of those will qualify as a disability under the ADA. Next slide. So, what does substantially limited mean? What does it mean to be substantially limited in one or more major life activities? You compare the person's ability to perform the major life activity with how most people in the general population would perform that activity. And it should not require a lot of investigation, a lot of digging into. You may have to ask for some documentation in employment, but really it should be relatively easy to determine whether or not somebody is substantially limited. One example could be if it takes somebody normally 15 minutes to walk half a mile, but it takes somebody who is substantially limited in the major life activity of walking 45 minutes to move half a mile, that person could be substantially limited. If you're in a quiet room with one other person and you cannot hear that other person talking, you could be substantially limited in the major life activity of hearing. So it's what most people in the general population can do. And Congress said when they passed, in particular, the ADA Amendments Act in 2008, that they want broad coverage of disability. They want a lot of people to be assumed to be covered by the ADA. Next slide. So, what does record of an impairment mean? It means you have a history that substantially limits of that impairment that substantially limits one or more major life activities, even though you may not have that impairment or that disability now. And that could mean an example of an employee that has a history of asthma, although that asthma has not acted up in years, but he is not allowed to participate in some outdoor activities required for his job because his manager is concerned his asthma may be triggered. If he is not allowed to participate in those activities, and those are essential job functions, which we will learn about later, he could lose his job because he's not allowed to participate in those, even though he could easily do so, and the asthma is not currently active. So he is somebody with a record of an impairment, and he is covered by the ADA. Next slide. So what is regarded as the third section of the definition? That is a person who is treated as if they have a substantial limitation on a major life activity, even if they do not have that disability or any other disability for that matter. So an employee could have a tic where she blinks her eyes frequently, and she may not be invited to staff social gatherings because the manager thinks she has a cognitive disability. Now, even if she did have a cognitive disability, it would be discrimination not to invite her to the staff social gatherings. But there may be various reasons why the manager may think she's distracting to other people and should not be allowed, for example, in client meetings that they have. Next slide. So there are many types of disabilities that employers may encounter and that employees may have. Again, this is a partial list. Physical disabilities, hearing disabilities, visual disabilities, speech disabilities, neurodiversity, autism, that could include ADHD, um, cognitive disabilities, learning disabilities, sensory processing disabilities, mental health disabilities, health related disabilities, including long COVID, which is now considered a disability if you are proven to have long COVID. Next slide. So, who has rights under ADA Title I? Job applicants and employees that are already on the job both have rights under ADA Title I. So, who is covered by ADA Title I as far as the obligations that Title I puts forward? That is private employers with 15 or more employees. In California, that's private employers with 5 or more employees. And then state or local governments of any size, it does not matter how many employees they have. Also, unions and employment or temporary agencies are covered as employers and have obligations under ADA Title I. Next slide. So, qualifications for the job must not screen out or even tend to screen out people with disabilities in those job obligations. They must be related to the job and not just be completely unrelated. And they must be necessary for the operation of the business or nonprofit, whoever it is that is the employer. And they must allow the essential functions of the job to be performed with or without reasonable accommodations. And we will be talking about reasonable accommodations. But the qualifications generally are described as any educational or employment experience that you need to have to get a job in the first place. But you don't have to be qualified, quote unquote, for your disability. It's the qualifications for the job, and they again need to be necessary and job related. Next slide. So, how do you decide what job functions are included in a job description? Employers, please listen carefully to this. You don't have to have a written job description under the ADA, but it is highly recommended to have that and to make sure that you have it before you advertise the position. Make sure that you're listing the duties that other people in the same position perform or have performed in the past. Um, And you also want to list duties of past employees in similar maybe positions, as long as they apply to that particular position. You also, if you have a union employer, you need to look at the terms of any collective bargaining agreement you have to see what those terms say about the job functions and what's included in the job description. Ultimately, the job description is up to the employer. Employers should be very careful to make sure that when they list which job functions are essential and which are marginal, which we will talk about, that they are being clear about that and that they are not requiring things that are not really required in order to be able to do the position. Next slide. So an essential function, really, those are the functions that the job exists to do. You can kind of think of that. And they are important and necessary job duties. And the person must be able to perform these duties with or without a reasonable accommodation. And the person has to be qualified for the job. Again, those educational or employment qualifications, whether or not they need an accommodation. So that's separate from the accommodation analysis. And then marginal functions, as opposed to essential functions, are tasks that are not essential to the job. And other employees could do those functions. They could trade those functions or assign those functions to other employees to do if it is not possible for the employee with the disability to do those with an accommodation. So employees and applicants are considered qualified for a job when they satisfy the skill, experience, education, and other job related requirements with or without reasonable accommodation, and they can perform those essential functions of the position. Again, the employer needs to determine whether or not they're essential. And for example, don't include something about having to have a driver's license, which the truth of the position is that you just need to be able to get to various points of the job, but you may be able to get there on the bus or in a taxi or some other way. So it's not required that you have a driver's license in order to perform the position. So be careful when you are listing those essential job functions. Next slide. So I'm going to turn it over to my colleague Pat to take you on this journey.
Okay, thank you, Jan. So we're going to talk now about disability inquiries and documentation. Next slide. So first, we're going to talk about pre-employment. An employer cannot ask any pre-employment questions specifically about a disability or how significant it is. And so that's important. Before employment, none of those questions can be asked. Next. So what can an employer ask about disability generally? Employers, again, cannot ask about an applicant's or an employee's disability. Employers can ask how an applicant will do the job with or without one or more reasonable accommodations. And we'll talk a little bit more about reasonable accommodations. So they can ask how they can do the job, but they cannot ask specific questions about the person's disability. If an employee is having trouble performing their job and an employer thinks an accommodation would help, the employer can discuss the possible accommodation with the employee. That's totally acceptable. Okay, next. Requesting disability documentation. An employer may require that the documentation about the employee's non-obvious disability and the functional limitations come from an appropriate healthcare or rehabilitation professional. You can't ask for an accommodation unless you disclose your disability. And then that documentation needs to come from a healthcare professional, doctor, therapist, an appropriate healthcare professional. And the documentation needs to be current, usually within the past 3 years. Employers should ask about functional limitations, not necessarily the diagnosis, and what would be helpful as an accommodation. And that information can come from the healthcare professional as well. The healthcare professional does not need to say what the diagnosis is. They can say what the limitations are for that person and what would help them do their job. Next. Medical examinations pre-employment. An employer may not ask or require a job applicant to take a medical exam before making a job offer. And so we'll talk about that in a little bit. Next slide. So an employer may make a job offer conditional, however, on the employee passing a post-offer medical examination or medical inquiry if this is required of all entering employees in the same job category. So if the person with a disability is asked to have a medical examination and everybody else is not, that is not okay. A post-offer exam or inquiry does not need to be job-related and consistent with the employer's operation. But if the individual is not hired because a post-offer medical examination or inquiry reveals a disability, the reasons for not hiring the person must be job-related and consistent with the employer's operations. That's a whole lot of words there. And so if the person does not get the job, it needs to be because of reasons that are related to the job and consistent with the employer's operations, not because they just have a disability. Okay, next. So the post-offer again, if a medical exam reveals a disability, the employer must show that no reasonable accommodation would allow the person to perform the essential functions, or that such accommodation would impose an undue hardship to disqualify the person. So if the medical exam reveals a disability, the employer can't just say, we're not offering you the job. They need to consider reasonable accommodations, and is there something that they could do that would help this person do the work? A post-offer medical examination may disqualify a person if the employer can show that the individual would pose a direct threat in the workplace. A direct threat is a significant risk of substantial harm to the health or safety of the person or others that cannot be removed or reduced by making a reasonable accommodation. Okay, next. And so if the person is on the job, after a person starts work, a medical examination or inquiry must be job-related and consistent with the employer's operations. And those words, those specific words, are all through the employment sections of the ADA. Job-related must be connected to the job and consistent with the employer's operations. Employers may ask if an employee medical exam, employers may ask for an employee medical exam where there's evidence of a job performance or safety problem, or the examination is required by other federal laws like transportation providers, or the employer needs to know an employee's fitness to perform a particular job, or the examination is voluntary and part of an employee health program. Okay, next. So now we'll talk about reasonable accommodation. So what are the important things to know about disclosing a disability? So when a job applicant or employee needs a reasonable accommodation, they must disclose their disability to an employer verbally or in writing. Employers are not required to guess. So you cannot ask for an accommodation and not tell your employer why or disclose your disability. If no accommodation is necessary, however, you don't need to disclose your disability. There's no reason to do that. Employers can request additional information or documentation if the person's disability or the best accommodation is not obvious. So this is a conversation that happens between the person with the disability and the employer. The answer is not always cut and dry. Employers must keep information about disability and or medical conditions confidential. This is very important. HR or whoever is working and doing this process with a person with a disability must keep this information confidential. The information cannot be disclosed to other people in the workplace. Okay, next.
And they must also keep that information separate from your performance information because they should not be looking at your disability when they're judging your performance on the job. Yes.
Right. Okay, what is a reasonable accommodation? Any modification or adjustment to a job, an employment practice, or the work environment that makes it possible for an individual with a disability to enjoy an equal employment opportunity is a reasonable accommodation. Okay, next. So what employers must provide under the ADA in this case? Reasonable accommodations to applicants and employees with disabilities. So they must provide reasonable accommodations. They must provide accessible locations for the job. So the person with a disability must be able to get to the work site. They must be able to get into the work site. They must be able to do their job in a place that is accessible to them. They're provided with accessible websites, including the employee training. So if there's beginning employee training and a person is blind, there must be software on the computer that they can use, accessible websites as well. Communication aids and services for employees and applicants with speech, hearing, and or vision disabilities when required for effective communication. So they may need special devices to help them in their work. And employers must provide reasonable modifications to some policies and procedures. So if there are some policies and procedures that need to be adapted, changed, modified for individuals with disabilities, employers must do that as well. Next. So here are some situations when accommodations may be required. First of all, to help an employee to perform the functions of the job, to give a job applicant an equal employment in hiring or recruiting, or to prevent discrimination of employees with disabilities in the terms, conditions, and privileges of employment. So again, it's from the whole hiring process to being in the actual work environment to the end of employment, if that happens.
And the terms and conditions can be something like making sure a retirement party is accessible or a company picnic or, other things like that that are associated with the employment.
Okay, next. So here are some examples of reasonable accommodations. Job reassignment or structuring, modifying or getting equipment, providing auxiliary aids and services for people who are deaf or blind or have speech difficulty, allowing use of service or emotional support animals, allowing use of paid or unpaid leave for treatment or service animal training. For instance, your dog is sick and needs to get to the vet or needs special training, you're allowed paid leave or unpaid leave to do that. Accessible workstations. There may be a time when somebody needs a stand-up workstation because of a back injury. Modified work schedules or leaves of absences. Modifying policies or procedures, including telework. Changing when or how an essential function is performed. Or reassignment to a vacant position, and that's usually as a very last resort. And these are some examples of reasonable accommodation. The list is endless, and it all depends on what the person needs to do the essential functions of their job. And so there are many, many more accommodation examples. Okay, next. And so effective communication helps individuals with disabilities who are blind, deaf, or have speech disabilities. And so providing effective communication for them can be done through qualified sign language interpreters, assistive listening systems and headphones and sound coming through different listening devices, volume control phones, captioning and caption phones, screen reader software, qualified readers who have a specialty in signing for things like legal language, medical language.
That's more,
And
this be people who are qualified to read documents to people who are blind.
Yes.
Yeah.
And large print or braille documents. Okay, next. And so the ongoing nature of the duty to accommodate. Once a person with a disability has an accommodation, that is not the end of the process. It is ongoing. So a change in the workplace is the reason why accommodations often don't stay the same. Changes may require changing an existing accommodation, providing an accommodation where one was not needed before, or stopping an accommodation that was provided before. So there may be times when a person no longer needs the accommodation they originally requested. They may need something else. And so it's an ongoing process between the person with a disability and their employer. Next. So what kind of changes may happen? And again, there are more than these, but there could be change in the nature of the limitations caused by the disability or the use of what are called mitigating measures, like medication, hearing aids, and wheelchairs. So the person may not need quite the accommodation that they originally asked for because they got correct medication or hearing aids. Changes caused by restructuring, like layoffs, consolidation of jobs, or changes in job duties due to advances in technology. Changes in the company's procedures and policies, changes and forward progress in technology and medicine that are used to mitigate or improve disabilities, and changes caused by promotion, job transfer, or non-ADA changes to job duties. And again, this is why it's necessary to keep the conversation open and active regarding what a person with a disability needs and having those conversations with their employer.
And we
Yeah.
suggest that people get accommodations in writing, whether that's through email or some other, I mean, an accommodation agreement that everybody signs is really helpful, because if you have a new manager and the new manager says, I'm not going to provide that accommodation anymore, you may want to be able to have some documentation about that.
Right, right. Okay, next. And so reasonable accommodation and undue hardship is another consideration. The ADA requires employers to provide reasonable accommodations to employees or applicants with disabilities who need them, except when such accommodations would cause what's called an undue hardship. And that means a significant difficulty or expense, and focuses on the specific employer's resources and situation. So again, this is an open discussion, and these factors must be considered. Not only financial difficulty, but also reasonable accommodations that are too complicated, too large, or disruptive, or accommodations that would fundamentally alter or completely change the way the business operates, could be considered. So the employer may enter into this conversation, and what the person with a disability is asking for is too complicated or too disruptive to the business. That doesn't mean that the person is not allowed an accommodation, but other considerations, there may be some other conversation to be had about what might work for that person. Okay, next. And so this conversation between the employer and the employee is called the interactive process. Next. And so there are some guidelines for reasonable accommodations. The process is interactive. It's an interactive one between the employer and the applicant or employee, and it must be effective. You can't just have a conversation and the employer goes, okay, we talked about it, we're done. It must be effective. It must work for the employer and the employee. It applies only to accommodations that reduce barriers to employment as they relate to the person's disability. So the person can't be asking for, all kinds of things that are not related to what that person needs to do their job. It has to be related to their disability. It doesn't have to be the preferred accommodation if it is effective and specific to the individual employee. But employers can provide an accommodation beyond what the ADA requires. So it doesn't have to be the specific thing that the person with a disability is asking for. If it is effective and it works, then that's fine. Also, the employer can go beyond and do other things that would also work for that person with disabilities. Okay, next. And how does the accommodation request start? An employee or applicant notifies an employer of the need for an accommodation. You could do that in writing or talk to the employer, or a representative of the employee or applicant notifies the employer about the need for an accommodation. It doesn't have to be the applicant or employee. It could be somebody related to that employee, a representative. Or an employer knows the employee's disability, knows about the disability, and that employee may or may not be able to make such a request. So the employer can start the interactive process. Okay, and next. And so what happens next? The employer and employee continue to discuss possible accommodations until a reasonable, effective accommodation can be found. An employer can request medical documentation if it is necessary to understand an accommodation request, job-related and consistent with how the employer does business. And again, the employer does not have to request medical documentation, but they can do that if they're not sure how the accommodation and the disability go together. So they need more documentation, they can go ahead and request medical documentation. Both the employee and employer should act in good faith as the accommodation process moves forward in a timely way. The employer can't just put it on the back burner and months go by and it's not addressed.
And I know somebody asked about that. There's no specific timeline, but good faith is really the key.
Yes. It is best to have a written agreement about reasonable accommodations that is signed by the employee, the manager, and human resources. And just as Jan said, for instance, and we've actually had calls about this, where a new manager comes in, a new owner of the company comes in, and there is no record. There's no written record of a person's reasonable accommodation, and they have to start from the beginning. Okay, next. And I think, Jan, this is yours.
So let's talk about employment defenses and limitations. And we've already kind of talked about some of this previously. Next slide. So undue hardship that we mentioned earlier. It's an action that requires significant difficulty or expense. So that's kind of how it's defined when you consider several factors. And those several factors could include the cost of the accommodation, the size of the employer and the resources that the employer has, the nature of the accommodation, how difficult, how expansive is the accommodation the person is saying that they need, and the structure of the employer's operation are all included in things that you would look at to see if there's an undue hardship. And that employer really needs to be able to show that it is truly an undue hardship, and explain that to the employee and show this and not just simply say, this is an undue hardship. Next slide. Can also have a direct threat that we mentioned earlier. And that is defined as a significant risk. So a big risk of substantial harm to the health or safety of the applicant or employee or to others in the job environment that cannot be eliminated or reduced by a reasonable accommodation. This is going to be very rare that a person would pose a direct threat in employment, but it is possible. It is possible, for example, that someone has a seizure disability and works on an assembly line. And if they have a seizure and it's uncontrolled by medication, if they have a seizure and that could result in the assembly line equipment doing something dangerous to them or to someone else down the line, that's an example of what could be a direct threat. Again, it's going to be very rare, and it has to be based on reasonable medical judgment, not simply an employer saying this person poses a direct threat. It has to be the most current medical knowledge and or the best objective evidence available. It cannot just be based on the employer's opinion that someone poses a direct threat. Next slide. So we have several questions, and after this, we also have some resources for you, and we will be sending you these slides that you will have, and we have many more resources. Also, if we go another slide or two where we have our contact information, if we move forward, so here's the resources that we have. There's many more. And then I would just leave it here on this slide. So this is how you can contact us at our 800 number. If you are anywhere in the country, you can call this 800 number and get the ADA center that corresponds to whatever state or region you live in. Also, you can contact us by email, info@adapacific.org. Please check out our website at adapacific.org. It is in plain language, and we have tried to make it as easy as possible to navigate. You can also scan the QR code to get to our website. And you can also join our email list at adapacific.org/subscribe. And we send out a monthly newsletter that's extremely important and that contains lots of great information and other training that's available. And please also follow us on social media. Follow us on Twitter, Facebook, and LinkedIn, and YouTube as well. We have a YouTube channel. So we encourage all of that. And we've got lots and lots of questions here, which we will not be able to get to all of them. I'm trying to think in terms of what what we started out as the questions. So let me see if I can get to the first questions after people introduce themselves. So one of the things says, why do you have a service dog? You don't look disabled, LOL. Okay, that was, I guess, a comment that somebody received. And remember, in employment, you could have a service animal, you could also have an emotional support animal. If you can engage in the interactive process with your employer and your employer agrees that it's okay to have an emotional support animal and they're under control enough in the work site, and you can contain them and you can also take them outside to do their business, then you can actually have a service animal or an emotional support animal in employment. So that's important to know. And then the next question that I see is the list of major life activities specified in the ADA? And you don't necessarily have to have the complete list. I gave you a partial list. There are many possible major life activities listed in there, but there are major life activities. There are also major bodily functions that are considered major life activities now in the ADA Amendments Act. So keep in mind that it could be a major bodily function like bowel or bladder function, endocrine function. You know, people who have diabetes, they are substantially limited in endocrine function. People who have cancer are substantially limited in major cell growth because their cells are growing too fast. That's what cancer is. So there are a lot of possible major life activities or major bodily functions that could be included. And again, Congress really intended for the ADA to be broad, to cover a lot of people. And so you need to keep that in mind in employment and in the other titles of the ADA as well. Okay. Um, so let's see. Regarding the need for assistive listening devices at work, how should one be able to request in order to keep them in meetings in particular? So you may need to be able to keep them on the job site and be able to use them when when you have the meetings, and your employer should be able to purchase that for you and have it available to you when you're having meetings. Okay. And are undocumented employees protected by the ADA? People who are undocumented in terms of immigration status are covered by the ADA, but that gets tricky in the job context because if you're not legal to work in the United States, you still have to comply with the laws that require you to be legally able to work. The ADA does not exempt you from those laws if you are somebody who is undocumented with a disability. But the ADA does protect you in other ways as far as the ADA is concerned, with effective communication requirements and reasonable modification requirements, particularly in Titles 2 and 3. And if you can become legal to work, then yes, the ADA would protect you also in employment. And again, somebody mentioning the driver's license requirement, that should not be a requirement unless it's absolutely necessary, but it could be a requirement to be able to get to multiple locations on the job in a timely way. Um, so yes, you will all get the slides, and it's one of the things was asking about AI captioning, that's often used instead of a live captioner in meetings. And yes, a live captioner is always best, but sometimes the employer may not be able to afford that. So sometimes they may use AI captioning, but I would just really ask whenever possible to have a live captioner because it does make a difference in terms of how the live captioner is hearing somebody, and particular when someone has an accent, when somebody may have a speech disability, maybe they have cerebral palsy, and the AI captioning doesn't understand them well. So make sure that if you are using AI captioning, that you are correcting it as much as possible. Um, Okay, so and again, there is no necessary form for accommodations, but we just recommend that people maybe have an accommodation in agreement that is signed by their manager and HR if they have an HR and themselves, and that it's dated so that if a new manager comes in, they can't say, well, we never agreed to that. You will have an actual documentation of that, but it's not required by the ADA as such. So please do take a moment before we close out today. Paige has included in the chat for you a link to our evaluation. We really want you to give us feedback. So please click on that link, give us feedback through SurveyMonkey. It will only take a very few minutes to do. And Paige also included a link to receive your certificate of attendance as well. So that's in there. And you can always get back to us if you're not able to get that. So, but please, we do ask you to please fill in the evaluation. We do look at those. It is really important that people evaluate our training. So there are no CEUs, I'm afraid, for this webinar, but we will send you a certificate of participation, and you may have to get to whatever entity you are trying to get credit from. I know the ADA coordinator certification, you could get credit for this webinar for that. But for CRC, I'm not sure. You may have to have done that in advance. So thank you all very, very much for attending. Are there any final questions before we sign off for today and before you complete your evaluations for us? The certificate link did not work, I see someone saying. Someone else is saying it worked for them, so I'm not sure. I'm not sure. If you still need a certificate, you can let us know. Okay, info@adapacific.org. And other people are saying they got their certificate. So good, I'm glad you did. And please, please fill out your evaluation. And thank you all very, very much for joining us today, and celebrate INDEEM next month. The National Disability Employment Awareness Month is October. We wanted to do this session on employment before that. So celebrate the National Disability Employment Awareness Month next month by doing something to raise awareness about disability and employment and the ADA. So thank you all.